And welcome back. Now, families of the Life Esidimeni tragedy won't see justice served just as yet. Now, despite damning findings by former Deputy Chief Justice Dikgang Moseneke into this particular matter, the National Prosecuting Authority says that there isn't enough evidence to charge anyone at this stage. Now, several senior Gauteng government officials were implicated in the deaths of 144 mentally ill patients, and many were tortured and starved to death after the Gauteng Health Department cancelled the Life Esidimeni contract and moved people to underfunded and ill-equipped NGOs. The NPA received 144 dockets for investigation, but they've now referred the matter for a formal inquest in the High Court. And to discuss this matter further, we join now by Michelle Toxopeüs. I hope I'm saying that's right.
Yeah.
Thanks so much. And of course, she's a legal researcher at the Helen Suzman Foundation, and Jack Bloom, Democratic Alliance's Gauteng Shadow Health Minister. Thanks to both of you for coming through. Now, Jack, let me start with you. You've been basically at the forefront of exposing this particular tragedy. So looking at this latest turn of events, does it come as a surprise to you?
Well, I'm relieved that at least something is happening, but I must say I'm disappointed that now they tell us that they don't have enough evidence for murder and culpable homicide charges, and I hope that this inquest process establishes enough evidence so that we could have those charges. But my disappointment really is that there's a whole range of other charges that they could have easily proved in court, contravening the Mental Health Act, fraud, corruption. And I think one of the big things actually was that licensing illegal NGOs. Now, the evidence for that was very clear, and I think we could have gone to court in that and got convictions. So really, there's a whole range of charges that could and should have been laid by now that we could have seen at least some justice. But look, I'm hopeful that the inquest process establishes the necessary evidence for the big charges, murder and culpable homicide. Obviously, that's where we want to see the justice, but we also want to see accountability for a whole range of infringements.
And I think along with you, many South Africans would have thought that at least from the Ombudsman's report, from the arbitration process, from other investigations, that there would be some prosecutions taking place, but not at this stage. What is your understanding? What sort of reasons were you given for the NPA not being able to proceed?
Well, what they've said publicly is that they don't have the standard of evidence to prove murder and culpable homicide. So this is going to appear before a High Court judge, and hopefully they do get that evidence. But I've been asking questions in the Gauteng legislature about the progress of investigation as a whole, and I think there it's been inexcusably slow. As I said, we've got cast-iron evidence that these NGOs were illegally registered. There's an offence in itself, and I would like to see those charges coming to court. The problem is if you go with all or nothing, is that you can end up with nothing, because it just drags on interminably, like Marikana, where we've not seen any justice whatsoever. So I think what the NPA needs to consider is a range of process, doing the charges that they can do now, and then the more difficult ones can come later. But otherwise, we're going to see very little progress in this, because the delays in our criminal justice system, this is problematic. I think they can get people convicted on the evidence they already have for other charges, and they should do that as soon as possible.
So, Michelle, you've written extensively about this particular tragedy and the legal processes in particular. So what was your reaction to the NPA's announcement?
Well, initially, us at the Helen Suzman Foundation were taken aback by the decision. But on further, introspection, we've, for criminal liability, for there to be a successful prosecution, you have to be able to prove certain things, and one of those is that the act can be linked to the death. So that the decision, there must be some cause, and there must be a link to that, and that's, there's a factual causation and there's a legal causation, and factually maybe that's what everybody is thinking. yes, there's likelihood that it can be linked, but legally it, brings in a lot more. It's a lot more technical. It's complicated, and so for the NPA to be satisfied that they have a watertight case, that there will be successful prosecutions within this, it might be the prudent decision to gain extra evidence and for them to be able to successfully prosecute.
So how is this formal inquest going to differ from the processes that we've already seen, the arbitration, for example?
So the arbitration, that was a decision taken by the or recommendation from the Ombudsman, the Health Ombudsman, where he suggested that an alternative dispute resolution take place. And the parties decided on arbitration, which is a binding form of alternative dispute resolution. But that's a civil liability. So that's where you get compensated. And we saw with the arbitration that the families got compensated. Whereas this process would be to establish, the legal elements for a crime. So, which is a higher burden of proof on the state. You need to prove beyond a reasonable doubt that that this person can be prosecuted successfully for the crime.
And which is where I guess it becomes quite confusing for the general public, because during that arbitration process, for example, the former Deputy Chief Justice Dikgang Moseneke did find that some government officials at least acted in breach of the law and the Constitution. And therefore people are asking, so what more needs to happen in this regard? Is that not sufficient finding in this instance? And maybe, Jack, if you'd like to respond, and Michelle, I'll get your response to that as well.
Yes, well, there was confessions, basically. People admitted that they did wrong, particularly with contravening the Mental Health Act and registering illegal NGOs. Now, that's a very clear-cut infringement. The evidence is all there. Clearly, and none of this would have happened, quite frankly, if the NGOs hadn't been illegally registered. And the former head of department and the former head of the Mental Health Directorate both admitted to it. So, I mean, there's a self-admitted crime, as I see it, in the arbitration process. The evidence is there. Obviously, when it comes to court proceedings, you have to start anew, but you really know what you're looking for, and you can rely to some degree on what was said in that arbitration hearing. You could get convictions on that. So I think the public are wanting to see results. I know the families really do want to see justice in this matter. So if on the most serious charges, murder and culpable homicide, the NPA goes this route, gathers the extra evidence that there can be a successful prosecution in court, I agree. There's nothing worse than going to court and losing the case. But I think that there are other infringements that can go to court, and there can be successful convictions, and I think that's what we need to see.
So that's the question then, Michelle. From a legal perspective, why hasn't the NPA then chosen to go with those cases that are clear-cut and prosecute at least those for the time being? Does it all have to go together?
So the NPA's decision to kind of bundle it all in one is something that they have probably discussed internally. The arbitration decision, and I think that's what is confusing for the public and frustrating for us all, is that the arbitration decision did find that the decisions were irrational. But that, of course, is a different test. And the inquest perhaps will bring further additional information to the fore that can be used for different, charges. Because that's what the inquest will do. It will look into the death and the causes and the circumstances in the death further. And the judge will have to make a finding which is binding.
But as Jack points out, in the instance where people have come forward and confessed to wrongdoing, where the arbitration process pronounced on the wrongdoing in that regard, why would the NPA not proceed with those cases, at least in the meantime?
Sure. For one thing, there's different crimes that can, as Jack stated, there's different crimes that can be charged. But just so there's different elements that you have to prove as a crime, and one of them is unlawfulness, and that it is a crime. And then the other is causation. So they are different elements in a crime, which still have to be proven beyond a reasonable doubt. So just because something is unlawful doesn't mean that it caused the crime that this person has been charged with.
Yeah, makes sense. But then we've already had 3 years since these deaths occurred. How long is this process likely to take?
This is very frustrating for everybody, and I've been disappointed at the level of police resources. They only had 4 detectives working on it. Now there's 144 deaths. There's also terrible mistreatment of more than 1,000 people who were sent to these terrible NGOs. So I don't think that the police have worked as fast as they could, and that this really could have had better progress on this. And I'm going to continue to be asking questions of the Gauteng legislature on progress, and hopefully there's enough pressure that we see results.
So again, how long? Do we have any indication of how long this could take going forward, and when are they going to start?
So it's a I think it will be a very long process, because I don't think we've seen something on this scale, 144 dockets, and we're unsure how the NPA will approach this, whether they will only take a few dockets or whether they will go for all 144. And I mean, the prosecutor has the option to consolidate them and for the judge to hear them all at once. We're unsure at this stage but what we're sure of is that it's probably going to be a very, very long process.
And just bringing it back to the families, Jack, any update on the compensation that was meant to be paid to the victims and families?
Well, the 145 families that were part of the arbitration process have all been paid. And then, of course, Justice Moseneke opened the door for further claims. There's been at least 300 of those further claims. Not all have been paid, and I'm distressed that there have been some delays, but I think most of them have. I mean, that's just basic. This is the government has to comply with that, and I hope that is finalized as soon as possible. But really, money can't compensate for the deaths and the suffering that occurred. People want to see justice, and I think that's where we're reliant on the NPA and the police to do their jobs, bring it to court and get the convictions.
And has everybody been accounted for?
Well, there's now 9 missing patients. I asked a question in the Gauteng legislature this week, and we don't know the whereabouts of 9 people. I think this is utterly tragic, because you might have to add the fatalities to the 144, because if you can't find the 9 missing people after 3 years, can we really believe that they're still living? So, look, I think this has been a tragedy on many, many levels. And it's also the suffering of those who survived as well. And we want to see justice. We want to see a full range of accountability, not just those who are accountable for the big things, but also the small things as well. I think there was massive fraud and corruption, stealing of money. You can't believe what people did in this whole terrible saga.
Well, we're going to have to leave it there. Thank you so much to Michelle Toxopeüs, legal researcher at the Helen Suzman Foundation, and Jack Bloom, Democratic Alliance's Gauteng Shadow Health MEC, giving their reaction to the NPA's decision that a formal and joint inquest into the deaths related to Esidimeni tragedy be held in the High Court in Pretoria before a judge of that court. So we're going to leave it there for now.